Hello everybody, I'm Susie Frankel on behalf of the Law Faculty, the New Zealand Centre of International Economic Law, AMINS and the Law Foundation. Welcome to this event. We have full speakers and hopefully a bit of time for discussion and interchange today. First, let me give you a bit of background. So, in the last 18 months at different times, and also including here, we were privileged to host Gary Bourne in the New Zealand Centre of International Economic Law as our first inaugural Senior Visiting Research Fellow. And as part of that visit and part of Gary's international work, a remarkably small part but a remarkably big project, Gary is the author of the Bilateral Arbitration Treaty. And this treaty has, as many of you know, many aims and many goals, but one of those goals is to provide better dispute resolution for small and medium enterprises. As New Zealand is really a country of small, very small and very small enterprises, some of which we might even call medium, this is a really important issue. But of course it's also quite a controversial issue because arbitration itself has many meanings, many faces, many benefits, many costs, and so on. So we're going to begin today with a presentation from Hanneke van Oeveren about small and medium enterprises and legal frameworks. Really, if you like, setting, I hope, a big picture about small and medium enterprises in New Zealand. That will be followed by a presentation from Chris Nixon, who's the senior economist at the New Zealand Institute of Economic Research, and Georgia Whelan, who, like Hanneke, is one of our students of whom we're very proud here in the law school, looking at the cost-benefit analysis that they have done of the Bilateral Arbitration Treaty. I'll leave them to explain the details of cost-benefit analysis, but would like to, in particular, welcome Chris back to the law school, where we've had an ongoing series of work here, also together with the Law Foundation, about how lawyers can talk costs and benefits and economists and how we can all work together. Because although, as you know, lawyers and economists spend a lot of time together, they're also exceptionally good at talking past each other. So I see this as continuing the development of law and economics working together, and particularly for the New Zealand community. Our guest of honour, Gary Bourne, will follow with comments. Of course, this is his baby, the Bilateral Arbitration Treaty, and he will finish up with whatever comments he sees fit. But I would, before handing over to our speakers, just like to take a moment to acknowledge my colleague and one of our very important researchers here in the law school, Petra Butler. As you all know, she is in fact the tour de force that has us all in this room. So without further ado, thank you, Petra, and welcome, panel.
Good afternoon. We're humbled that you've given up your lunchtime to be here today to attend this seminar. My part in this seminar is to present the research I conducted into the contracting methods of small and medium-sized enterprises in New Zealand. My interest in small businesses and their international contracts sparked primarily from discussions with my dad, who owns a small manufacturing business that is almost entirely reliant on overseas markets. The title of this presentation is taken from the response of one of the SMEs. He was asked why he perceived an international transaction to be more risky than a domestic one. He said, the obvious risk is that if we have a disagreement, we have basically no legal standing. I'm sure that we do, but I don't even know what it is, and it hurts my head to think about it. In the same context, another participant said, we operate on the assumption that if an international contract is not performed, we will not be able to enforce performance. Statements like this were pretty startling for me as a law student. This is not the kind of thing I'd read in my law books. During my research, I interviewed 10 SMEs from diverse sectors and from around New Zealand. The participants ranged from very small-scale food producers to the manufacturers of specialised machinery, right through to specialised software service providers. The SMEs were asked a range of questions about their contracting methods and about their perceptions of international trade. All Although the pool of 10 businesses is only small, I gained an invaluable insight into their practices and perceptions. To provide an interesting contrast, I also spoke with one United States SME and one large New Zealand company. For this short presentation, I would like the SMEs as much as possible to be able to speak for themselves through the quotes that I have from the interviews. Consistently with the findings in NZIER's survey, which Georgia and Chris will discuss, the majority, although I must stress not all, of the SMEs did not have a practice of using formal contractual documents. Contractual documents are particularly important in the international context in order to allocate things such as the applicable law and the dispute resolution mechanisms. The lack of contractual documents means that it is more likely that SMEs will be left with recourse only to default mechanisms. In the context of dispute resolution, we're talking about cross-border litigation. The following passage from the International Chamber of Commerce's book on drafting and negotiating international commercial contracts recognises the situation. If business people involved in international trade and the lawyers assisting them have been able to overcome, to a great extent, the difficulties of international commercial transactions, it is because they have found a way to fill the gaps in the system through recourse to party autonomy. When one participant in this project was asked about his contractual documents, he said, "Lots of people don't have contracts. Forget contracts. I mean, it's a joke. It's silly. You don't have contracts at our level." Incidentally, the very same participant claimed his international transactions to be governed by the law of the jungle. Another participant was also unconvinced that contractual documents furthered his commercial aims. He said, "No, we don't have contracts. We have done it in a previous business I was involved in, and we did at various times discuss contractual agreements with suppliers, but they become super complex, and you spend all your time crossing the T's and dotting the I's. If it is not working, we part ways. We work on a gentleman's agreement with our dealers." On the other hand, one small business who had been involved in a complex web of international litigation in the past responded differently. They said, "Part of it was not being organised enough, and that was small town mentality. We still had the mentality of, oh, we're a small business, but we needed to have trade agreements in place. Then at least you have something, some grounds to say that if there's a dispute, here's what the deal is." The reality is that for many SMEs, one unanticipated or badly managed legal dispute could be the end of the business. The diversity of New Zealand's smaller businesses cannot be overstated. However, I have identified some characteristics which are relevant to how many SMEs approach and perceive international transactions. Firstly, in many cases, SMEs are run by a single owner-operator who must multitask. The time and energy of the multitasking owner-operator is a valuable resource which must be allocated carefully. They may be responsible from everything to the day-to-day running of the business, the management of human resources, right through to the approach to international transactions. Literature supports that this factor means that the time and energy that can be spent on preventary measures, such as drafting contracts and considering dispute resolution, is much more limited. Another factor is the importance of relationships. There was a recurring theme of a mistrust of contractual documents. Business-minded negotiators in small businesses may have some reluctance to using legalistic-looking documents that use verbose or wordy clauses to contemplate everything that could possibly go wrong with the particular transaction. One participant said, "Good relationships are important to me. I am not really interested in doing deals for the sake of the deal. I would much rather work on relationships than signing documents and working at a level of distrust." Another said, "For a layman like myself, even reading a legal document is already something. You have a bit of an idea what it says, but what it really means, you don't really know." When asked whether he ever used a lawyer for international transactions, a third participant said, "A 10-minute discussion with my solicitor. We were sending a machine to the UK. I had known the dealer for a long time and there was mutual trust. but I knew that once I sent the machine, it was effectively out of my hands. He would have it and I would own it. I had a 10-minute discussion with my solicitor, but he said it was a complicated thing, so I said, well, forget it, and go with the handshake. A third factor is a lack of access or willingness to access legal advice in relation to unfamiliar legal issues. One participant reported, "My terms and conditions say that only New Zealand jurisdiction applies. But what does that mean, you know? I mean, maybe in the other country there is a rule that no foreign jurisdiction will ever apply to their companies." Of course, the cost of legal advice is inevitably a factor. For us, the amounts are just too small. If we are doing a deal with $50,000, the profit margin may only be 10%. If we use a lawyer, poof, half of the profit is gone. Perhaps most concerningly, when asked about the use of drafted documents for international transactions, one participant reported that, "I wouldn't have a clue where to start, and I also probably would fear that if I went to my usual lawyer, he wouldn't have a clue either." A final factor, which is related to the lack of legal advice, is unfamiliarity with the dispute resolution mechanisms available. Extraordinarily, one participant who claimed he was not familiar with international arbitration, but did have a practice of using contractual documents, said, "If there was an internationally known agent for cross-border disputes, and I don't know if there is, for example, we go to X and we do our disputes by X, as renowned cross-border disputes agency, you know, with a bunch of people like yourself working together in Zurich or something, I think it would be quite good to have that." The mechanism desired by the participant bears very close resemblance to international arbitration. Given that he wasn't sure that it existed, it seems unlikely that he would negotiate for its inclusion in his contracts. The one United States SME I interviewed was asked what he perceived as the advantages of litigation and/or arbitration. He said, "I think arbitration is a more appealing process, just because we're a small business and we're very fast growing. To engage in anything that takes a lot of time and a lot of expense is unappealing. Arbitration would be preferable in that sense." Many of the SMEs involved in my research did not use formal contractual documents, leave alone dispute resolution clauses. Many SMEs simply do not have the time, energy, or resources to consider issues such as dispute resolution. On the other hand, the lack of effective access to justice embodied by the statements quoted at the outset of this presentation suggests that the current legal framework and dispute resolution mechanisms may not adequately be serving the needs of New Zealand's SMEs. So how does this fit in with Gary Bourne's proposal for a bilateral arbitration treaty? Under the BAT, the treaty states would agree to substitute international litigation with international commercial arbitration as the default dispute resolution mechanism for businesses trading between the treaty states. Importantly, the businesses would remain free to opt out of the BAT and so could, for example, choose to have their disputes resolved by litigation. The BAT would leave SMEs in an enhanced default position in the unfortunate situation that they had become embroiled in a legal dispute. The BAT would ameliorate many of the deficiencies of the current default system of cross-border litigation. For example, the risk of parallel proceedings in more than one jurisdiction is avoided. Similarly, SMEs wouldn't face the burden of accessing legal advice in more than one country. The arbitral awards rendered under the BAT would also be much easier to enforce across borders. The BAT would offer a neutral and streamlined procedure designed specifically to deal with disputes between businesses in the treaty states. What I see as the most important advantage of the BAT is that it is not reliant on effective contractual drafting by SMEs. It is clear from my research that many SMEs do not even think about providing for dispute resolution. For this reason, it is important to provide an easy, fair, and cost-effective dispute resolution mechanism available in the unfortunate situation that a dispute has arisen. The BAT is attractive because it provides a default dispute resolution mechanism which is more neutral, more cost-effective, and more suitable for the resolution of international disputes. To finish my presentation, I would like to leave you with the words of one of the participants. The participant was particularly interested in the TPPA and how it could improve his situation for selling goods in the USA. He said, "Dispute resolution is probably at least as important as a tariff, because the 10% that I would have to pay on top is probably less of a barrier than US traders not feeling confident to trade with us. It's good that the tariffs are gone. That will be beneficial for our business. But I think that in reality, that is not what would stop us. This other thing is far bigger. If they felt confident that they could sue us just as good as if we were in Florida." Thank you.
Well, good afternoon. First of all, a confession. This is probably not going to be a cost-benefit analysis. In typical economic style, we started off thinking about, yes, we'll do a full-blown cost-benefit analysis, but as we got the research results coming back, the ability to actually attach numbers to the process became retreated the further we looked into things. And so I'm actually quite grateful that Hanneke's started us off, because she's shown us how nuanced the issue really is. So with that little caveat to start, the other thing, of course, is we've kept the cost-benefit analysis structure. So we've thought about it in terms of a cost-benefit analysis. We just haven't got the answers we thought we'd get. As with a number of pieces of work that we do. I suppose I should really start off with some context here. We've seen huge changes in commerce in the last 20 to 30 years. Globalisation is really starting to impinge upon where we are, and even in faraway New Zealand. Our trade policy settings are changing, and we need to think about that a little bit more. We're moving away from things like trade policy, tariff, quotas, and thinking about those sorts of things, and thinking about integration. And so this is the issue that we're sort of focusing on, is how do we improve integration in our markets. And so what that means is that there is a focus on institutions, the rule of law, not only in New Zealand, but in our export destination countries. So in that respect, things such as the BAT become very, very much more important, because it confronts that issue head on. It's the quality of the institutions in the receiving countries and in New Zealand, which are very, very important. Even though I suppose BAT is something which might go under the radar a little bit. But it also nicely fits in with what we're obsessed with in economics, and that is really about risk reduction. How do we reduce risk for our exporters to get into export markets, and how they think about these things. And so the hypothesis was, well, will BAT actually help this process that I've just described? So in economics, we have this sort of idea that it's about questions, it's about theory, and it's about data. And if you think about questions and theory and you don't have any data, you're basically just manipulating. So you've really got to bring the three together when you're thinking about these things. So the point about this exercise was to think about a practical assessment of what we might be looking at. But just to think about the questions and the theory for a minute, the point is we think it is a risk reduction. This is our ingoing hypothesis, really. We think about it as a risk reduction exercise. We want to improve participation by exporters, the number of exporters, and also the volume that each exporter is exporting. And, when we think about the beehive over there, we also think about, there are government aims, not just of this government, but of previous governments, to improve our export agenda and see that as a focus. And also, I suppose, to remove uncertainty for those exporters. And possibly, in the long run, think about how it might improve some of the institutions in the exporting countries. And so that's an important thing. So now I'll hand over to Georgia, who will talk about some of the findings of the survey.
Cool, thank you, Chris. So we sent out this 2-page survey, which is a little bit stretched and you can't quite see it clearly. It was comprised solely of multiple choice questions, and we sent it out to 145 businesses in December 2015. By January 15th of this year, 44 responses had been received. Of these, 37 firms did not have international dispute experience, and 7 did have some experience. The results of our survey were used to assess businesses' views on international dispute settlement processes. The first 6 questions of the survey were aimed at establishing the characteristics of the firms. We chose not to be selective in only surveying SMEs to discern whether there is a difference in the practices of varyingly sized businesses. The second half of the survey was focused on establishing the potential costs and benefits of a BAT to New Zealand exporters. The survey was divided into 2 columns to attest to whether opinions differed between those with and without international dispute experience. Of the businesses surveyed, 23% identified as SMEs, and approximately 77% could be classified as producing final and intermediate goods and services. The results showed that 56.9% said they do form formal contracts for international transactions, whilst the remaining 43.1% said that they do not. Here we and Hanneke have assumed that businesses would interpret the phrase formal contract as a complete written document intending to contain all the terms of the agreement. We also found that SMEs were more likely to not form formal contracts. This could be indicative of the smaller nature of their exporting practices and is consistent with what Hanneke found in her interviews with SMEs. Of those who do conclude a formal contract with their trade partners, 72% responded that they do include dispute resolution clauses. These firms would fall out of the scope of a BAT. However, the firms who are exporting without contracts or without dispute resolution clauses would be within the confines of a BAT should a dispute arise. Given that later results showed that these firms prefer arbitration to litigation, a BAT could work in this context. The survey also established some key features about current exporting practices. Only 34.1% answered that their preferred method of dispute resolution is dependent on the country with whom they are trading. A further 47.7% were unsure as to whether this was important. This is particularly pertinent given that New Zealand's largest source of overseas income is Australia. Due to the proximity and similarities between the 2 economies, SMEs may be lulled into a false sense of security and think that alternative jurisdictions are similar. We also found that firms without international dispute experience would prefer to use negotiation as a means of dispute resolution, This was followed at a distance by New Zealand litigation and then mediation or expert determination. For firms with experience, negotiation and New Zealand litigation or litigation in the other party's country stood out as the most commonly used methods. Thus far, unfamiliarity with arbitration appears to be the main barrier to the successful implementation of a BAT in New Zealand. However, arbitration use in New Zealand is increasing, so this cannot be perceived as insurmountable. In particular, it is important to remember that the BAT would be a default mechanism only that firms are free to opt out of. In terms of their response to default arbitration, firms were wary of the implications of a BAT to their businesses. This was evinced by 70.5% believing that there would be at least a little cost to their firm. However, there was a broadly positive response by the firms in that 66.7% prefer arbitration to litigation to resolve international disputes. The unsure results at 30.8% are symptomatic of the preference for negotiation over and above litigation or arbitration. Breaking this question down into responses by firm size varies the story a little. SMEs are more sceptical about the proposed benefits of default arbitration. This could be indicative of their unfamiliarity with international arbitration or due to a stronger domestic focus for their firms. However, to put this into perspective, foreign litigation is likely to cause more issues for these firms than an arbitral tribunal. Larger firms had a more positive response to default arbitration. Additionally, 54.5% believe that there will be a little or a lot of benefit arising from default arbitration. The main costs identified were expense, management time, delay, and unfamiliarity with procedure. These are all understandable given their preference for less adversarial methods of dispute resolution. There are concerns over greater costs for a more formal approach. For example, management time with the BAT means the extra time needed to understand arbitration and upskill. This is in line with Hanneke's description of the structure of SMEs, from which it is clear that management time is scarce. The expense of arbitration makes sense, as these costs are likely to be greater than what firms have experienced with negotiation. There are, however, methods that can be incorporated into a BAT to reduce the cost of arbitration. For example, this could be achieved by time limits, a sole arbitrator, or document-only proceedings. This would also help mitigate the delays that firms may experience. Nonetheless, firms would be worse off with the cost of litigation and the possibility of drawn-out proceedings and appeals. There was a marginal drop in the risks when comparing the group with international dispute experience to the group without. In retrospect, it is evident these firms are using methods outside of alternative dispute resolution to mitigate the risks they face with international trade. For example, transactional-based methods may be preferred by these firms. These ad hoc arrangements are managed sensibly by SMEs to minimise potential losses, but they are still at risk of facing international litigation. The primary benefits identified were the independence of arbitrators, decreased negotiation costs, lower costs of dispute resolution, and the expertise of arbitrators. The combination of these benefits highlight arbitration as a fair dispute resolution process that produces enforceable and expert results. However, the benefits identified do not necessarily correspond with what the firms isolated as the most notable potential costs. Decreased costs were identified as a benefit. Nevertheless, firms also selected the expense of arbitration as a cost. This juxtaposition is characteristic of how unacquainted these firms are with international arbitration. However, these benefits also show how the procedures arising from international commercial arbitration and a BAT will result in a neutral expert tribunal coming to a final and enforceable award compared to litigation, where judges are perceived to favour the domestic party and have a parochial outlook on international disputes. We also found that the answers elicited a clear distinction between the firms with and without international dispute experience. Without international dispute experience, the main benefits became decreased negotiation costs, expertise of arbitrators, the enforceability of arbitral awards, lowered dispute resolution costs, speed, and the independence of arbitrators. However, the firms with experience identified the independence of arbitrators, the confidentiality of awards and proceedings, access to justice, and certainty as the primary benefits to arise from default arbitration. A greater proportion of those without experience were unsure as to what the benefits would be, whereas the firms with experience were more confident in identifying the potential advantages. This is distinctly related to the relative experiences these firms have with international dispute resolution. And on that note, I'll hand you back over to Chris.
So, the point with this is, I sit there and I scratch my head when we started to look through these results, because essentially what we're seeing here is a degree of uncertainty about how to respond from firms. This is not going to be a surprise to you, Hanneke. And actually, the fact that you've done some independent research which sort of corroborates what we got back from our results was actually a huge relief. But the point is, we really need to get a better understanding of how firms look at these issues. Some understanding of the theory of the firm associated with how are they thinking about this. How are they thinking about, is it just with Australia, for example, that they are thinking? Or further afield, how are they thinking about those issues? Are they thinking about them as a one transaction off, and then saying, well, and then if the supplier actually pays up, then they're using them more. It's also, when half of the firms sort of said that they don't have contracts, so they're going through processes which are very much at least costs. It does sort of suggest we need to understand this a little bit more. The other thing is, I suppose if government was going to address this area, they would have to get a reference group of a dozen or so SMEs who have been through the process of international arbitration. I think that would be a far better way of going about it than imposing a particular bat. It also seems to me I haven't got much time. You're giving me these other things, and I just don't have the time to do this. So I'm not going to worry about that. But it seems that if you've got a bat up and running, and people could see the demonstration effect of a bat going, then you might have some positive results as time went on. So I don't see this as being, oh, good, we've put it in place. It's actually watching firms see the demonstration effect associated with a bat and seeing how they could actually pick out the advantage. And this seems to be important because of the structure of our exporting community, small group, small SMEs involved, and also further on, the fact that Asia is still growing despite what we hear, and they will be wanting to suck in more imports. And so the destination of Asia is certainly going to be a major part of where we're going in the next 30 odd years. It also could mean a reduction in risk and also and help lift our export performance. Thank you very much.
So, thank you very much for the excellent research. I learned, as I'm sure everyone else here did, lots of things from the careful work that has been done. I suppose, like any economic research, you can interpret the findings in various ways. I interpret the findings as an unequivocal and resounding confirmation that bilateral arbitration treaties, BATs, not just make sense, but are urgently needed. And I'll explain that conclusion because it might require some explanation. I'd like to start, as Chris did, with a little bit of the context. We're in a world where two things are happening that are inevitable and to some extent the deliberate result of government policy. The world is globalizing, not just here in Asia, whether or not TPP happens, but globally. There is more and more cross-border trade. Some years there's more than other years, but one of the clear trends over the past 20, 30 years, both here in New Zealand and elsewhere, is vastly increased international commerce, vastly increased importing into New Zealand, exporting out of New Zealand, provision of services by New Zealand entities, use by New Zealand companies of services from abroad. And every indication is that will continue and continue robustly, both for larger, but also importantly for medium-sized and smaller businesses. The second observation is that is a result of deliberate government policy. The government, whether it's through free trade agreements or export subsidies or TPP, deliberately encourages New Zealand companies to do business with foreign counterparts, deliberately encourages, because it's a good thing for New Zealanders to trade with foreigners, to sell products to them, earn profits from revenues abroad, or to purchase cheaper goods from abroad. Those two observations lead me then to pick up on Hanneke's basic observation on an anecdotal level, which I would like to say a few words about structurally. And that basic observation is when all of these small, medium-sized, and large New Zealand companies do what the government and historical trends encourage and impel them to do, they are left with, put really simply, the law of the jungle. They are left with a world in which to enforce the most basic of their commercial rights, they need to go to foreign jurisdictions with which they have no familiarity. Some of those jurisdictions are just fine. Australia is just fine. The UK is just fine. That's why instruments like the Tasman Proceedings Act, which essentially makes Australian courts the same as New Zealand courts and gets rid of jurisdictional and enforcement of judgments issues, makes perfect sense. Most of the world is not like Oz. Most of the world is like China or the United States or India or Indonesia or the Philippines. Those countries' courts, whatever their virtues are for Chinese and Americans and Indians and Indonesians, are not good places for New Zealand companies, especially not in international disputes. To some extent, one hears that anecdotally, but one needn't only look anecdotally. There are reams of empirical evidence done by people like Transparency International about the incidence of corruption globally and in especially places like what I had just mentioned. Even if you're only talking about corruption in 20% of all cases, and that's probably a charitable figure for some of those countries, that is an unacceptable number and helps explain why this is the rule of the jungle. Even in situations where there isn't corruption in those countries, one looks routinely, and again, there is a host of empirical research on this, and one looks routinely at court backlogs measured in decades, not days. One looks at tribunals, decision makers, entirely unsuited for international matters, and even without corruption, biased in the strongest possible way in favor of parochial interests. Since my accent is American, I can use America as an example, but the notion of a lay jury picked precisely to favor local interests against foreign interests is, from an international level, shocking. It may make sense for Americans for their particular domestic and internal reasons, but in terms of a dispute resolution mechanism for foreign businesses doing business there, it makes no sense at all. And therefore, I would suggest there is already a wealth of empirical evidence out there as to why the anecdotal reports of a rule of the jungle, not instead of a rule of law, is what prevails and what confronts our, and this will come to the second set of my comments, our unwitting SMEs when they do what the government encourages them to do and what history forces them to do, namely export into foreign markets or purchase from foreign markets. It is therefore no surprise at all that in lots of places of the world, institutional efforts have been made to address this very problem. The Tasman Proceedings Act between New Zealand and Australia, even though the New Zealand-Australia cross-border trade is, in a sense, the easiest of all problems to resolve, given the close cultural, historical, legal, and developmental characteristics of the two countries, even though that's a very easy problem to resolve, it is one that lawmakers thought was very important to resolve. We don't want parallel proceedings. We don't want jurisdictional disputes. We don't want difficulties in enforcing judgments. We want to fix all that. All that very reason is so much more important when you have vast disparities in legal culture, legal background, approaches towards corruption, court delays, differences in legal procedure and substantive laws. It is so much more important when you're talking about China and India and the United States than it is in the context of Australia. So the real question is, when countries come to focus on this issue of cross-border trade, they come up with institutional solutions. They come up, in the case of Australia and New Zealand, with the Tasman Proceedings Act. They come up in the case of Europe with the Brussels regulation, aimed at doing on a more imperfect scale within Europe what was done with the Tasman Proceedings Act, and they come up in the United States with the full faith and credit clause and personal jurisdiction rules. There is perceived to be a problem with cross-border dispute resolution that requires institutional resolution, and especially requires it today, given the forces of globalization and the export promotion drives. So the real question is, what institution makes sense internationally? What institution makes sense for resolving international commercial disputes? And I think the sort of an unstated premise, and this really brings me to the final set of my remarks, the unstated premise that we probably all bring to this is, well, it's business. Businesses can take care of themselves. It's their problem. They're the ones that know what kind of contracts they want to enter into. They're the ones that draft the terms of their agreement. They're the ones who can be relied upon to agree to choice of court or arbitration agreements, which will solve all this. We'll basically privatize this problem. We will leave it to individual businesses to figure out what best suits them. And to some extent, that is a fair response, because in some cases, parties do think about this. We heard in 55% of all cases, small and medium-sized enterprises will have some sort of contracts. We didn't have how many of those contracts actually have working dispute resolution provisions in them, but we have, even assuming that all of those contracts did have a well thought out and effective dispute resolution provision, we still have basically half of all contracting parties in the sample not addressing this issue. And we have eloquent explanations for why that's so. They're too small and too distracted by other things and wouldn't be able to understand the complexities of these issues, and given the nature of their business, they can't afford to pay to understand the complexities of those businesses. In circumstances, and this is really the conclusion to my observation, in circumstances where history has compelled those companies to export and the government has encouraged them to export, it is incumbent, I would suggest, on the government then to provide an adequate default solution in the very large set of cases when, for perfectly understandable reasons, small and medium-sized enterprises, and frankly, large large enterprises don't turn their mind to solving the problem. And the problem is, as my examples from Transparency International and backlogs of 20 years and unenforceability of judgments from New Zealand abroad, I think illustrates very clearly a serious problem. It is not enough to say, given what we know about contracting practices now, it's not enough to say we'll leave companies to work this out on their own. The reality is, given the economic structure of their businesses, they're just not going to ever be able to work it out on their own. So essentially the choice is between doing nothing and leaving half of all small businesses without legal rights and in the rule of the jungle, going forward with things that we encourage them to do, or alternatively to do something. We did something with the Tasman Proceedings Act because we saw that was important. Europe did something with the Brussels regulation. The question is, what should we do with all of the other trade, the 50% of the SMEs that don't take care of themselves in the rest of the world where the law of the jungle prevails? My suggestion is the bat. I think the focus should be on how do you tinker with the bat? How do you make the bat better? And I'd be happy to talk about that either in this or another forum, but it's clear that one needs an efficient, both in terms of time and costs, means of dispute resolution. One of the hats that I wear is president of the Singapore International Arbitration Center. One of the procedural innovations that we have adopted at SEAC, and which I think would recommend itself to small and medium-sized enterprises here, is an expedited procedure by which for disputes of amounts less than $3 million US, SEAC, the arbitral institution, can require a sole arbitrator, fast-track proceedings that will be concluded in 6 months, on a documents-only basis if the arbitral tribunal concludes, the arbitrator concludes that that is acceptable, with an award within that 6-month period. No doubt, one could come up with procedures that would be more thorough, more rigorous, would turn over more rocks and allow more disclosure and more witnesses, without doubt. One could do a more perfect job of dispute resolution. That's not the question, though. The question is, how can you best resolve these at least 50% of all cases where nobody's thought to pay any attention and can't afford really to pay that much attention because it's a $50,000 dispute. We can either say we don't care about $50,000 disputes, we don't care about SMEs that have $5 million a year in turnover. This is their problem, we know they can't fix it, but let's forget it. Or we can say, let's come up with a mechanism that provides appropriately tailored justice on with proportionate procedures to give these people something other than the rule of the jungle. In a school devoted to the rule of the law, I think that's the least that we can do. Thank you. I'd be happy to take questions for sure.
So this is a chance for you, of course, to raise any questions, both about the research done and, of course, the motivations for the bat, of which there are many, and I'm sure Gary's heard many times about going into bat for the bat, and so on and so forth, and deliberately choosing this. So, as many of you know, and I was deliberately quite brief in my introduction, Gary himself, I've actually thought, without discussing this, why are we getting the bat from someone who, if I can say so, has contributed hugely and therefore benefits hugely from large arbitration? And I think that actually that's quite telling, right? So to the extent that when one is advocating for something, we always want to know who, why, what their background is and what they're bringing. So if I can add to Gary's comments, his background is both a successful career as a person representing sides in different disputes, as an arbitrator, resolving those disputes, both as a panelist and the chair of arbitration panels, and also as a researcher looking into these bigger questions. The volume of Gary's work is huge, so we won't go through all of that, and as he mentioned, he holds a number of positions. So would adding the Bilateral Arbitration Treaty necessarily add anything to Gary's life. I think that what he's telling us is, yes, it would, because it would expand the scope of arbitration, but does he personally need it? Not particularly. So without being facetious or too colloquial about it, I think it's important to understand that this actually is a really good opportunity for countries of this size, where everyone struggles with the cost of litigation, but it's, roughly pro rata, economists in the room, forgive me, according to the size of a nation and the size of its businesses. So this really is actually quite a unique opportunity, because what we know as New Zealanders is that often it's the small going, hello. And so it's useful to have representatives, if you like, from larger dispute settlement bringing to this. So I'll add that flavour and turn it over to your questions and comments for the panel. Great.
I had a question. It might be for Hanneke. Thank you very much for that. It's all very interesting. With those, is there evidence that in these international contracts that risk is reflected in price? Or is that one of those areas where there's such an information deficit and so little capacity to think through those issues that we don't even see the risk of doing cross-border transactions factored into the price for the contract?
I don't know if this is completely answering your question, but I did speak to a few of the businesses, more than a few almost, did say, oh, well, we always require advance payment, so we won't ship something unless it's already been paid for, so we don't care about dispute resolution, was sort of the... So I guess that sort of in a way is saying, well, we think there's no risk, so... But obviously, there's other risks, but I don't know if that sort of answers the question. I'm not sure if Gary...
I didn't make these observations when I was speaking previously, but I thought that Hanneke's findings about small and medium-sized businesses really underscored the need for a default solution, in the sense that it's obvious that small and medium-sized businesses don't understand what they're doing. They may think they're not concluding contracts, but one of the first things we learn in Contracts 101 is they actually are concluding contracts. They may not be concluding contracts very wisely or properly, and they may not be documenting them, but they've got contracts. They may not be including dispute resolution provisions, but there will be default dispute resolutions imposed on them. And so, and one entirely sympathizes with Hanneke's father, who is spending his time running a $5 million a year or whatever business, and he doesn't want to hear about the Tasman Proceedings Act, much less the Bilateral Arbitration Treaty. He probably, in some intuitive sense, and I certainly see this from my larger clients, factors in some of this uncertainty in his pricing and other terms. I want payment up front. But I have to say, my experience being at a large firm, much more with multinationals and folks that are supposed to be very sophisticated, is that even the most sophisticated companies fail in an extraordinary number of cases. Perhaps not 50%, but more than 15% to include dispute resolution provisions in contracts, even where the company has a very clear policy. Always have a dispute resolution provision, even where the company has a host of templates that say, here's the arbitration clause that you ought to use, here's what you shouldn't accept. Businessmen, businesswomen just don't turn their minds to legal or technical issues nearly as often as here in this law school we as lawyers might think they would.
I'd also like to add to that New Zealand is such an easy place to do business in. So, people doing business here in New Zealand, and then they go to Australia and it's just as easy. But it's the leap on, which we want them to make, which is I think is the issue, whether that be in Asia or in the US. That is, to me, is the key. If we want to grow, it's going to be Asia, where this is the Chinese century, whatever the Americans may say. And we're going to have to do business up there.
And if it's not the Chinese century, it's the Indian century. And the courts there are not dramatically different.
Yeah, John.
Sorry, Susie, I want to take over from you. panellists, but just to say, there is work done that shows if the point, Graham, that you were making was maybe the exporters are kind of, if you like, concluding a bargain that they think is reasonable. They get a bit more risk if they go overseas, so they charge a wee bit more as an insurance policy. There's a lot of evidence that New Zealand exporters have really, really low market power, except in a few areas. And so many of them get around that by spreading their risk through different origins and or different products. Secondly, there's some direct evidence that shows that risk per se has an influence on exporters' exit. They'll leave the concept of exporters and or move back to safer harbours like Australia.
And that's not surprising in a sense, because the whole idea behind the New York Convention, behind the Tasman Proceedings Act, is that cross-border trade has peculiar risks and uncertainties, which intuitively makes sense. We want to reduce those in order to encourage that.
There's a question for Gary. I was just wondering, in terms of getting a New Zealand government, with this one, another one, excited about this project. As you'll know, our private international law system as a whole is pretty creaky and ancient and patchy. What other priority would you put forward if we were going to adopt this? Does it mean we can shortcut a whole lot of other reform we might have to do at some point on choice of law or other areas, or is there some other areas we need to brush up on at the same time?
That's interesting. I think this is standalone to some extent. I think this could be done not requiring other things also to be done, because one of the nice benefits of a bilateral arbitration treaty is that you, in a sense, piggyback on the existing world of international commercial arbitration, where there is extensive precedent in the form of arbitral awards, national court decisions, interpretations of the New York Convention, which the BAT is closely modeled on. So in a sense, one would get the benefits from a lot of international learning, as well as New Zealand learning. David Williams' book on international arbitration in New Zealand, Campbell McLaughlin, Petra's work, all would be directly relevant. I don't think you would need to do other things, and at the same time, I don't think the BAT would be inconsistent with doing other things. It wouldn't in any way be at cross purposes with either the New York Convention or the Tasman Proceedings Act, or if New Zealand were to want to go in that direction, the Hague Choice of Courts Agreement Convention. The BAT, as I mentioned, provides a default mechanism. It doesn't operate where parties agree to arbitrate and the New York Convention, or agree to a forum selection clause and the Hague Convention on Choice of Court Agreements comes into play. It's purely a default mechanism.
Is it default on enforceability of its awards as well? So what one interpretation of Bevan's question is, so if you submit to the BAT and you have your proceedings, where does that go for the enforceability? Because that might be an area that we would need to brush up on.
It might require, the basic concept of a bilateral arbitration treaty, of course, is that business-to-business commercial disputes that are international, unless agreed otherwise, must be resolved by arbitration. So there is a default rule with regard to the initial dispute resolution. That means if someone whose dispute falls within the terms of the bilateral arbitration treaty tries to sue in national court, they will be referred to arbitration, just the way that somebody who has an arbitration agreement today would be referred to arbitration. The BAT substitutes, if you will, for the contractual arbitration agreement. Equally, and this comes to your question, at the back end, once there is an award, that award would be subject in New Zealand and the other treaty partner to recognition and enforcement on exactly the same terms as the New York Convention. And so, to your question, there is a default mechanism in a sense. The award becomes recognizable and enforceable, and importantly, in preference to if there were ever a contrary national court judgment. It's hard to see how there would be if the treaty were respected, because the dispute wouldn't be litigated, it would be referred to arbitration. So the only decision that you should have would be coming out of the BAT tribunal.
So if you tie that to Chris's comments, maybe, what's your experience on enforceability of awards against Chinese companies? It's really the question.
Yeah, and there is international empirical research there. The research suggests that around 90% of all arbitral awards are voluntarily complied with, in part because people behave in the shadow of the law, and the New York Convention, with its enforceability mechanisms, casts a pretty long shadow. There's also a good deal of work done on the recognition and enforcement of arbitral awards in various jurisdictions, including China. The general results of that research is that national courts, including China, have been quite good about recognizing and enforcing convention awards and agreements, both at the beginning and the end of the process.
So the quality of the institutions.
I mean, it's interesting because you can, to some extent, again, the BAT would piggyback on, it would take advantage of a long history of experience with privately negotiated arbitration agreements. It would sort of slot in the BAT default provision. I'm not sure what we're doing outside.
Someone will arrive on the scaffold soon.
Batman.
I think we have time for one more question. Yeah. So there's one more question. Yes.
I'm a lawyer, mediator, and arbitrator from Zurich, Switzerland. Grateful to be here. I just have puzzled by one thing. We understand and see through our experience, arbitration, international arbitration, tends to be more expensive, sometimes even a lot more expensive than litigation is. And there comes a difference when you look at American domestic arbitration. It looks different because I think there are certain schemes that are different than in international arbitration. My question would be, would this BAT refer more to this kind of arbitration that is used in the U.S., which, in my understanding, technically would be less expensive because, number one, no reasons given, number two, in general, or number two, ex aequo bono, as a general way to decide. Unlike the international arbitration way, I'm just confused because you're saying, well, the 50,000 dispute amount should be considered something we need to deal with. I'm not sure whether international arbitration is really the way to deal with this, because is it really the possibility for somebody with this amount in dispute to refer to? I mean, is this realistic, or are we just shifting from one problem to the next problem, but at the end it will never be a possibility to deal with the 50,000 dispute, whether arbitration or litigation in an international situation.
We didn't set Hanneke up to refer to the international trade experts in Zurich. It's a useful question because it helps me dispel some very important misconceptions. I don't know anything about arbitration in the United States, domestic or otherwise. I know about arbitration internationally, but I don't know what the Americans do, notwithstanding my accent. It's really important when we think about arbitration not to confuse it with the headline arbitrations that we read about in the newspapers every couple months. International arbitration is not the Yukos arbitration where the Russian Federation gets held liable for $50 billion for expropriation of the Yukos company. International arbitration is not the Areva arbitration involving a nuclear power plant in Finland that is currently scheduled to take 10 years on a fast-track basis because it involves a $30 billion nuclear power plant project that went inconceivably wrong. International arbitration is not any of the horrible corporate messes that take years and tens of millions of dollars to resolve. Those are the sexy but pathological international disputes that international arbitration occasionally resolves. Tragically, most international arbitrations are small, boring, efficient, and inexpensive. Tragically for big firm lawyers like me, most arbitrations are resolved very quickly, very inexpensively. I didn't come to this, and this sort of takes us back to the Susie's very initial comments. I didn't come to this idea because I thought I would be creating a new line of business for large firm international arbitration practices. This line of business is more akin to what I saw at SEAC in our expedited procedure cases involving disputes of 200,000 Singaporean dollars or $1 million Singaporean dollars, where you appoint a relatively young sole arbitrator who is required to resolve the dispute on the documents in less than 6 months. Nobody makes much money from that case. What happens from that case, though, is that the rule of law gets provided to somebody who otherwise won't get it and can't afford it. And I intimated this in my comments before. It isn't the sort of $50 billion UCOS endless years of turning over every procedural stone and raising every conceivable conflict of laws issue and exploring every witness statement with meticulous detail. It is quick justice that will be inexpensive, because that is the best that one can do in that kind of setting. And so, coming back very directly to the question, this would be a cost-effective form of dispute resolution. It would be the most efficient form of dispute resolution, not the sort of thing you read about on the front page of the business section every couple months. I hope that answers your question.
So, do join me in thanking our panellists. I think we've opened a can of worms and many things we could keep discussing, but my view is that all good seminars mean that there's still issues to discuss. And that, thank you for our researchers. We're especially proud of our students, so Aline, thanking you.